Well, if you have been careful to register the copyright in the book before the infringement has occurred, you have a great advantage. If you haven't registered the copyright that you already own, that comes into existence automatically and instantaneously at the moment of creation, if you haven't registered it, do not despair. You can still file a lawsuit. You cannot recover your attorney's fees or statutory damages, but often you do not need to. You can engage in what we call the theater of copyright litigation. Very few copyright lawsuits actually go to trial. So here is the timeline of a copyright infringement matter. The author writes something. The author may or may not register that copyright with the Copyright Office. That is a mere formality, not a prerequisite to owning the copyright. The author discovers what he or she believes to be an infringement. The copyright owner contacts a lawyer. That would be a good idea. A copyright lawyer, not a personal injury lawyer, not a real estate lawyer, a copyright lawyer. Copyright lawyer will compare the original work with the work that is infringing, supposedly. And if there is substantial similarity, that's the test, substantial similarity, the copyright lawyer usually will send a cease and desist letter, a warning saying, you've stolen our rights, stop doing it, cease and desist. And then as a sort of an afterthought, also tell us how many you sold and how much money you make, because we're going to come for that. That's usually how it starts. And that opens a dialogue, and the author's lawyer and the defendant, the infringer's lawyers, have discussions. Sometimes they agree, it's plain and simple, and they agree to stop and they pay money. A lot of times they argue, and it's not as clear-cut as that. And if they're not able to resolve it quickly with a couple of phone calls, then it's time to file a lawsuit. Before a copyright infringement lawsuit can be filed, you have to have a copyright registration. It's the ticket to the courthouse. So if the author is lucky, he or she has registered the copyright prior to the infringement. And then they're going to win. Because it doesn't matter so much if there's infringement or not. If you registered it before the infringement, you're entitled to your attorney's fees if you win. And that is a great lever. That right to recover attorney's fees is what drives the lawsuit. It gives you leverage over the other side. For it's going to be hundreds of thousands of dollars that your lawyer will incur in fighting the case that you can add to your damages at the end if you win. And the other side knows that if they lose, they're going to pay the lawyer bill, which is going to be a lot more than the actual damages that you suffered from the infringement. So if it's registered before the infringement occurs, tremendous advantage. Often the case will settle quickly. Not always, often. No registration, do not despair. You run to the court, you run to the Copyright Office. You don't run, you just do it online, and you register the work, and then you get your registration. And the law is clear. The U.S. Supreme Court decided this year, 2019, you must have that certificate in your hand before you get in the courthouse door. California, for the last 20 years, has said, no, you just file the papers. It's okay. It's pending. Then you go to court. No more. You've got to have that. It's a ticket to the court. Now, you can expedite the registration process. It usually takes 9 to 12 months. You can get it done in like 5 working days. It costs like $800, but they'll speed it up for you. Get your ticket to the courthouse, your registration form, and that's the prop for your theater of copyright litigation, and you beat the other side of the head with it. We have the registration. We can now file our lawsuit, and then the lawsuit goes on, and they're really tough. You don't want to be, I have a litigation with a diagonal line through it, a sign. You don't want to be in a copyright lawsuit. They are very expensive. Being in front of a jury is like flipping a coin. Even if you have a slam dunk, 100% case, the best odds you have, the best odds in a jury, 50-50. You going to gamble $100, $200, $500,000 of money and legal fees on a 50-50 gamble? Usually not. And every lawsuit went to trial in California from, on the new act from 78 against the movie company has resulted in a defense verdict. It's obscene, it's wrong, it's insane, it's a miscarriage of justice. There are people writing law reviews articles about it, but that's the odds. Slam dunk case, it's going to be a defense verdict for the movie companies. It's a stacked deck, and then you got to win on appeal, and good luck with that. So yeah, litigation, don't want to do it. Take precautions, register the copyrights before you start passing copies around. It gives you a huge advantage and can short circuit a infringement claim.